Now let's speak to Lawrence Ma, who's chairman of the Hong Kong Legal Exchange Foundation. Mr. Ma, thank you for joining us on Global Watch. Now, Tong Yin Kit's trial will obviously be closely watched. Explain to us what the procedures will be under this new law.
Now, yes, Hong Kong's own criminal procedure will be used. The suspect will be brought before a magistrate. The magistrate will examine to see whether there are prima facie evidence that suspect could be convicted. If there is, then the magistrate will commit him for trial at the High Court. If no, there isn't sufficient evidence to convict, he will then be discharged.
And what safeguards are there for the suspect's legal rights?
The suspect has generally two rights and one presumption. There are two rights: the right to remain silent and the right to legal representation. The suspect can retain his own lawyer if he has insufficient means. A lawyer will be assigned to him by legal aid. The lawyer will accompany him at the police station to answer questions. He can choose to remain silent all the way and to say nothing. He would not be beaten to extract a confession because his lawyer are there, and if any such thing happens, the lawyer can complain to the court, and any confession would become inadmissible in evidence. Also, there is one presumption, the presumption of innocence, which means that the prosecution will have to prove each and every element of offense before the court, otherwise there can be no conviction.
Now, this national security law allows Carrie Lam to select judges for related cases. Now, do you think this could compromise judicial independence, as some critics worry?
Well, as far as we understand, this is only a system of designation and not appointment. Judicial appointment is done by an impartial tribunal, which is not affected by the executive. And this is the international norm, and it is well abided by in Hong Kong. Now, under the new national security law, the chief executive will designate from a large pool of existing judges to deal with national security cases, instead of hand-picking any particular individual judge to preside over any particular case. So which judge to preside over which case is a matter for the judiciary eventually. So judicial independence is not undermined.
And finally, Mr. Ma, this law provides for serious cases to be heard on the mainland. Under what circumstances could this happen, and do you think it would apply in this case, in Tong Yin Kit's case?
Now, under Section 55 of the National Security Law, there are only three types of situation that rendition or transfer to the mainland for trial is allowed. The first situation is the case is complex due to the involvement of a foreign country or external elements, thus making it difficult for Hong Kong to exercise jurisdiction over the case. Secondly, only if there is a serious situation occurs where the Hong Kong government is unable to effectively enforce the national security law. Or finally, only if there is a major and imminent threat to national security has occurred. The Tong case does not fall within any of these three limbs, so he will be tried in Hong Kong and not the mainland China.
All right, thank you so much for your insights. We appreciate your time. Lawrence Ma with the Hong Kong Legal Exchange Foundation.